Hearing in the interchange appeals.
Ms Rose.
May it please your lordships. I appear with Mr Pitchinen and Mr Pobjoy for Visa. My learned friends Mr Hoskins and Mr Cook appear for MasterCard. Mr Turner, Mr Pickford, Mr Brown, Mr Schaffer and Ms John for the AAM respondents, that's Asda, Argos and Morrison's. Mr Brearley, Mr Spitz and Ms Love for Sainsbury's, and Mr Khan and Mr Sebastian for the European Commission. As your lordships will have seen, these appeals arise out of 3 claims for damages for breach of Article 101 of the TFEU and of the Competition Act 1998, brought by retailers against the 2 payment card schemes, Visa and MasterCard. Retailers claim that certain of Visa and MasterCard's scheme rules, which provide for the payment of what are called MIFs, multilateral interchange fees, are a restriction of competition by effect between the banks that provide services to merchants who accept cards. And those banks are referred to in these proceedings as the acquirers. I'm sorry to see the water incident, let's get it out of the way early. And the market in which they compete for the business of merchants is referred to as the acquiring market. The scheme's defences to those claims are twofold. First of all, we say that there is no restriction of competition. And secondly, we say that if we're wrong about that, and the MIFs do restrict competition, then they are exempt from the prohibition in Article 101 because they generate efficiencies and benefits, including benefits for consumers. Each of the 3 claims was tried separately before a different judge or tribunal, and on the basis of different factual and economic evidence. Each claim had a different outcome in which different findings of fact were made. MasterCard, represented by Mr Hoskins, faced 2 claims. One was brought by Sainsbury's and heard by the Competition Appeal Tribunal, chaired by Mr Justice Barling. The second was brought by the AAM claimants in the Commercial Court and was tried by Mr Justice Popplewell. Mr Hoskins will tell you more about those claims in due course, but I want to tell you about the claim against Visa. That claim was tried in the Commercial Court by Mr Justice Phillips, as he then was. Visa was facing proceedings brought by a number of different retailers, which included both the AAM retailers, represented by Mr Turner, and Sainsbury's. AAM and a number of other claimants settled with Visa right at the end of the trial, after all the evidence had been heard, after the written closing submissions had been exchanged, but before oral closing submissions. All the evidence that was heard in that trial was evidence in all the proceedings. So AAM's expert witness was also a witness in the Sainsbury's case. By the end of the trial, Sainsbury's claim was the only man standing. And that was concerned only with the effect of Visa's UK MIFs in the United Kingdom acquiring market over the period since 2007. And the claim was simply that those MIFs had the effect of restricting competition. The trial in total took 39 days. 4 economists gave both written and oral expert evidence, addressed both to the question of restriction of competition and to the question of the efficiencies and benefits derived from MIFs. Oral factual evidence was taken from 24 witnesses, and there were a number of other witnesses who put in uncontested written statements. The court also, of course, considered a mass of documentary evidence. And at the end of that process, Mr. Justice Phillips decided in his first judgment, which your lordships have in core volume 2, starting at page 5757. I'm only going to give the MS numbers, which are both printed in the hard copies and available to you. He decided that Sainsbury's claim failed because Visa's MIFs did not have the effect of restricting competition in the UK acquiring market at all. He found that competition between acquirers for the business of merchants would be no less restricted in the absence of Visa's MIFs than it was with the presence of those MIFs. It is central to Visa's position on this appeal to explain in some detail to this court the reasons why Mr. Justice Phillips made the decision that he did, how that decision was based on the evidence that he heard, on the facts that he found, and on the evaluative judgments that he made that were based on the factual and expert evidence that was entertained by him. So in due course, I'm going to consider his judgment in some detail. In a second obiter judgment, delivered a number of months later, Mr. Justice Phillips went on to consider the question of exemption. And he found that if, contrary to his first judgment, Visa's MIFs did restrict competition, then Visa had failed to prove that the MIFs were exempt. The Court of Appeal overturned both of Mr. Justice Phillips's judgments. They overturned the first judgment on the basis that the judge had been wrong to make his own evaluation of the competitive effect of Visa's MIFs in the UK market. The Court of Appeal concluded that Mr. Justice Phillips had been bound to find that Visa's MIFs restricted competition by the decision of the European Commission, upheld both by the General Court and the CJEU, in the MasterCard case. In that case, the Commission had found, and the decision was upheld on appeal, that MasterCard's MIFs, over a different period of time, had the effect of restricting competition in a number of EEA acquiring markets. We say that that conclusion reached by the Court of Appeal is an error of law, and that is the subject of the first issue in this appeal. The finding in MasterCard, the European when I talk about MasterCard, I'm always going to be referring to the European case unless I specify otherwise. The finding in MasterCard was a finding of fact, not a finding of law. It was an evaluation by the Commission of the effect of MasterCard's EEA MIFs on competition in the relevant markets between 1992 and 2007, by comparison with the competitive situation that the Commission had found would have applied in those markets in the absence of MasterCard's MIFs. That is a factual evaluation, both of what happens in the factual situation and what would happen in the counterfactual situation. That evaluation depended on particular findings of fact made by the Commission about the MIFs themselves, what MIFs are and how they function, findings about the relevant markets, and findings about what would have happened in those markets in the absence of MIFs. Those findings of fact were in critical respects different from the findings of fact that Mr. Justice Phillips made on the evidence before him in relation to Visa's MIFs in the UK acquiring market. And much of the evidence on which those findings were based was not even in dispute in the Visa case. Mr. Justice Phillips was bound to apply any principles of European law laid down by the CJEU in MasterCard. But he was also obliged, as a judge, to apply those principles of law to the facts as he had found them to be on the evidence before him. Facts both as to the nature and function of Visa's MIFs and as to the competitive situation that would have applied in their absence. The Court of Appeal also overturned Mr. Justice Phillips's second judgment. The court accepted Visa's argument that the judge had failed to take into account much of the evidence put forward by Visa in support of its exemption case. Indeed, the judge had wrongly stated that there was no evidence in a number of respects when in fact there was evidence. The judge had also failed to take into account an important concession that was made by Sainsbury's in that case to the effect that MIFs up to a certain level were indeed lawful. There is no appeal before your lordships against those findings made by the Court of Appeal. However, the Court of Appeal remitted the issue of exemption to the CAT on the basis of two findings of law which in our submission are wrong. First, a finding as to the nature of the evidence required to satisfy Visa's burden of proving the defence of exemption. And secondly, a finding as to the proper interpretation of the second of the four conditions that must be satisfied in order for the exemption defence to be made out. That is the requirement that consumers must receive a fair share of the benefits generated by a restrictive agreement. And those findings of the Court of Appeal are the subject of the second and third issues in this appeal. Now, Mr. Hoskins and I have liaised in relation to our submissions in an effort to avoid duplication, and today I'm going to address your lordships on the issues of restriction of competition, that's issue 1, and on the issue of fair share, that's issue 3. Your lordships will find the list of issues, if you want to turn it up, in Core Volume 1, 4849. And then late this afternoon and continuing tomorrow, Mr. Hoskins is going to make submissions on issue 2, that's the question of the evidence necessary to satisfy the burden of proof, and on the issue 4 that arises only in his own appeal, and any further submissions that he wishes to make on issue 1. The way we've divided it is that after that, I have reserved a few minutes to make any further submissions in relation to the evidence on which Mr. Hoskins will be making lead submissions. Whether I need to use that time and how much of it will remain, obviously, depending on what Mr. Hoskins says tomorrow. So that's an outline of the issues and how I'm proposing to proceed. In summary, what I'm going to do today is, first of all, to address issue 1. I'm going to make submissions on what is meant by a restriction of competition by effect and how that is to be demonstrated. Second, I'm going to outline the factual background, how Visa's scheme works, what MIFs are, and the role that they play in that scheme. Third, I'm going to go to Mr. Justice Phillips's first judgment and look at the findings he made, how they arise out of the case that was being advanced before him by both Sainsbury's and AAM, and the evidence that he heard, and how those findings led him to the conclusion that the MIFs didn't restrict competition. Fourth, I shall address the question whether, given the findings of fact that he'd made, Mr. Justice Phillips was in fact bound by the decision in MasterCard to find that Visa's MIFs restricted competition. And that involves both considering the applicable law as to the circumstances in which a national court is bound by a decision of the European courts, and secondly, the decisions of the Commission and the European courts in MasterCard itself to see what was actually decided in that case. Then finally, I'm going to show you the Court of Appeal's decision and identify what I submit are its flaws. Issue 3 on this appeal is a very important point, but it's much shorter. It's a pure point of interpretation of Article 101 of the treaty and of the relevant paragraphs in the MasterCard judgment which interpret that provision. And I'm going to show you what we submit as the correct legal approach and why we say the Court of Appeal got that wrong. So that's a roadmap of the submissions I'm going to make. And can I now turn...
Before you do...
Yes, my lord.
Can I just mark up, as it were, a diversion from the roadmap?
Yes, my lord.
For those sitting behind you.
Yes.
It seems highly likely that the UK will have left the EU by the time the court comes to either make its decision or make a reference, if that's the appropriate course for us to take. And there's a great deal of legislative activity going on in relation to what the situation is to be after the 31st of January.
Yes.
It would be useful, very helpful for the court if parties are able to provide us with hopefully an agreed note of what provisions are relevant for us in the post-31st January situation.
Yes, I
in
understand.
relation to the status of the CGAU jurisprudence.
Yes.
And so far as relevant, it may be also commission decisions.
Yes.
And as to our power to make a reference.
Yes, yes, my lord. There is a slight wrinkle in response to your lordship, which is that the answer to that question is going to depend on the amendments to the Withdrawal Act, which have not yet completed their passage through Parliament.
Yes, it may be you may not be able to provide us with such a note
on a
until...
definitive basis. We may be able to indicate what is likely to be the position.
No,
but,
I would rather have an agreed definitive note,
yes.
But we don't need it
Yes.
necessarily in the next week.
No, well, my lord, I think given the parties' commitments, and of course
Yes.
this court will be very aware of the importance of the work-life balance, but we will provide it as soon as possible thereafter. So can I now turn to the legal framework for establishing a restriction of competition by effect? And your lordships have Article 101 of the TFEU in Authorities Bundle 1 at tab 14, and it's MS 431. So, at Article 101.1, the following shall be prohibited as incompatible with the internal market: all agreements between undertakings, decisions by associations of undertakings, and concerted practices which may affect trade between member states and which have as their object or effect the prevention, restriction, or distortion of competition within the internal market. And then there are some particular examples of particular types of agreement set out. And then at 3, there are the provisions for exemption. The provisions of paragraph 1 may be declared inapplicable in the case of any agreement or category of agreements, any decision or category of decisions by association of undertakings, any concerted practice or category of associated practices, which contributes to improving the production or distribution of goods or promoting technical or economic progress while allowing consumers a fair share of the resulting benefit, and which does not impose on the undertakings restrictions not indispensable to the attainment of these objectives, and or afford such undertakings the possibility of eliminating competition in respect of a substantial part of products in question. Now, we'll come back to paragraph 3 a bit later, but at paragraph 1 you can see it is directed to agreements between undertakings or decisions of associations of undertakings, and it's agreed that these MIF rules contained in the scheme fall within that definition, which have either the object of restricting competition or the effect of restricting competition. And
is it perhaps relevant in this case to pay attention to subparagraph A?
Well, my lord, it's not suggested by anybody that these are restrictions by object, which are automatically unlawful. And in a sense, part of the issue before the court is whether this is an objectionable agreement or not. And the only way you can analyse that is by looking at its effects. Because the claimants, and particularly AAM, say, oh, well, this is really just like a price-fixing agreement. But we say, no, it's nothing of the sort. So that is actually part of the question that you're testing when you look at the competitive effects of the agreement. And I'm going to later make the point that it is of some significance that there was originally an object infringement case run in these proceedings, but that was abandoned. It's only run in relation to effect. And where the only argument is about effect, the burden is on the claimant to prove the effect of a restriction of competition that they allege. Now, your lordships can see immediately that the focus of this provision is the restriction of competition, or the distortion of competition. what is meant by a restriction of competition. Before we come to that, just for your Lordship's note, we don't need to turn it up. This provision is of direct effect in the United Kingdom. There is an equivalent provision that deals with restrictions of competition in the UK market, which is in the Competition Act. It's called the Chapter 1 prohibition, and your Lordships will see that. It's set out in the annex to the Court of Appeal judgment. That's CV2, page 5290, and it's sections 2 and 9 of the Competition Act, which are in materially identical terms to these provisions. So what's meant by a restriction of competition, and in particular a restriction of competition by effect? The meaning of that concept has been considered by the European Commission in the guidance that it gives, and also by the European courts. And I want to start by looking at a decision of the Court of First Instance in a case called O2 in Germany, which is in Authorities Bundle 3. It's at tab 26. It's MS 1085. So this was a case which concerned agreements between mobile telephone operators for sharing infrastructure and for allowing one operator to roam on the network of another operator. And the question was whether those agreements had the effect of restricting competition. And the Commission had found that in certain respects there was a restriction of competition. If you look at page 259 in the report, it's 1086, this is in the head note, you can see that the Commission found, this is in the middle of the paragraph H3, that the national roaming provisions restricted competition, but they granted exemptions for specific periods of time. And you can see that the complaint was, the bottom of this paragraph, that the Commission had failed to consider what the competition situation would have been in the absence of the agreement, and also that the Commission's findings on the anti-competitive effects were not sufficiently established. So this case is directly considering the question of how you establish a restriction of competition by effect. And the legal analysis starts at MS 1103, where you see the heading Findings of the Court. And first of all, at 66, the Court makes the point that in order to assess whether an agreement is compatible with the common market in the light of the prohibition in 81.1, 81.1 is the precursor to 1011, it is necessary to examine the economic and legal context in which the agreement was concluded, its object, its effects, and whether it affects intra-community trade, taking into account, in particular, the economic context in which the undertakings operate, the products or services covered by the agreement, and the structure of the market concerned, and the actual conditions in which it functions. That method of analysis is of general application and is not confined to a category of agreements. So the first point is that this is an intensely fact-sensitive analysis, which depends on consideration of the particular features of this agreement and the particular features of this market as it actually operates. And then the second point at 68, moreover, in a case such as this, where it is accepted that the agreement does not have as its object a restriction of competition, the effects of the agreement should be considered. And for it to be caught by the prohibition, it is necessary to find that those factors are present which show that competition has in fact been prevented or restricted or distorted to an appreciable extent. The competition in question must be understood within the actual context in which it would occur in the absence of the agreement in dispute. the interference with competition may be doubted if the agreement seems really necessary for the penetration of a new area by an undertaking. Now, so 2 points there about restriction by effect. First, that the actual restrictive effect of the competition, of the agreement on competition must be established. And it must be established, of course, by the claimant, must be proved. And secondly, that the way that you prove it is by making a comparison between how competition operates in this market in the presence of the disputed agreement and how it would operate in the same market over the same period of time in the absence of the disputed agreement. And that's the analysis which is commonly referred to as the counterfactual. And then over the page, such a method of analysis, as regards in particular the taking account of the competitive situation that would exist in the absence of the agreement, does not amount to an assessment of the pro and anti-competitive effects. And then at 71, the examination required consists in taking account of the impact of the agreement on existing and potential competition and the competition situation in the absence of the agreement. And then at 73, they go on to consider whether the Commission did in fact consider what the competition situation would have been in the absence of the agreement, and secondly, whether the conclusions it drew from its examination of the impact of the agreement on competition are sufficiently substantiated. And again, you can see there that what they're talking about is a factual evaluation. And interestingly, no spoilers, but this appeal was allowed, one of the criticisms that the CFI made of the Commission's approach in this case was that the Commission's objections to roaming agreements were generic. They were not based on an analysis of the particular agreement in the particular market. And you can see that at 86, it's page 1107. It is apparent from those assessments that for the Commission, the very nature of a roaming agreement, such as that concluded by the parties, brings about a restriction in competition by reason of the dependence on the visited operator, which national roaming creates for the roaming operator. And then at 86, such general considerations which could be formulated in respect of any national roaming agreement are not based on any specific evidence showing they're correct in the case of the agreement concluded between O2 and T-Mobile. So there again, the CFI making clear that you've got to look at every individual agreement in its particular circumstances. You cannot simply say, because this agreement is of a similar type to another agreement in a different market, you just assume that it has the same or similar anti-competitive effects, because this is an effects analysis, it's not an object analysis. So that's restriction of competition by effect. Factual evaluation in the particular market, comparison of the factual and counterfactual. What does the European institution mean by competition and by restriction of competition? Competition is not a term that is defined in the treaty, but it has been considered both in guidance issued by the Commission and in case law. And if we go first to the Commission guidelines, they are in Authorities Bundle 3, tab 31, page 1638. As you can see, these are guidelines dated 2011 from the European Commission on the applicability of Article 101 to horizontal cooperation agreements. This type of, these guidelines from the Commission are not binding. They cannot supersede any inconsistent judgment by the CJEU, and that's a submission I'm going to be making later in relation to fair share, but they are relevant material for the court to take into account. And if we go to page 1644, you see the heading Basic Principles for the Assessment under Article 101. And then over the page at 1645, you see the heading Restrictive Effect on Competition. So they first consider a little higher up the page, restriction of competition by object. And then just above paragraph 26, they come on to consider restriction by effect. And at 26, they say if it's not object, you've got to consider the restrictive effects. And then at 27, they say this. For an agreement to have restrictive effects on competition within the meaning of 1011, it must have, or be likely to have, an appreciable adverse impact on at least one of the parameters of competition on the market, such as price, output, product quality, product variety, or innovation. Agreements can have such effects by appreciably reducing competition between the parties to the agreement or between any one of them and third parties. This means that the agreement must reduce the parties' decision-making independence, either due to obligations contained in the agreement, which regulate the market conduct of at least one of the parties, or by influencing the market conduct of at least one of the parties by causing a change in its incentives. Now, there are two elements that are being flagged there by the Commission as necessary to find a restrictive effect on competition. The first is that the agreement must be shown to have an adverse effect on one of the parameters of competition, such as price or output. And the second is that that effect must be produced, and you'll see they use the word must. This means the agreement must. That effect has to be produced by a restriction of competition between the parties or one of them and a third party. And by a restriction of competition, what they mean is that the independent decision-making of at least one of the parties is reduced or distorted. And they say that can either happen because of the actual obligations they're under the agreement, or because something in the agreement or the concerted practice is affecting their economic incentives and therefore the way that they act in the market. Now, it's not enough just to satisfy the first. It's not enough just to say, this is an agreement that causes higher prices, ergo, it's a restriction of competition. You've got to look at the reason why the agreement's causing higher prices. Is it causing higher prices because it reduces the decision-making independence of the parties? Another phrase that's been used by the Commission to describe this process is reducing the rivalry between firms. That's the process of competition. Now, if you see the footnote to this point, right at the bottom of the page, you see there's a reference to two cases, John Deere and Asnef Equifax, paragraph 51. And we get a further understanding of what is meant by restriction of competition if we look at Asnef Equifax itself. That's in Authorities Bundle 7 at tab 64. One of the common ways, I beg your pardon, my lord, it's 3143. One of the common ways in which parties are found, either by agreement or by concerted practice, to have restricted competition is by sharing confidential information. So if, for example, you have a situation where competitors on a market share with each other the prices that they're going to charge for their products, that affects the incentives of their competitors as to the prices they will charge for their own products. Because if you know that next week your rival cheddar manufacturer is going to be charging £1 for half a pound of cheddar, you know that you don't have to price your cheddar any more cheaply. So that's affecting your incentives on the market. The sharing of information is reducing your uncertainty about the way that your competitors will act on the market, and therefore reducing your decision-making autonomy and distorting your economic incentives to act on the market. And this is that kind of a case. This was actually a case about financial institutions sharing credit ratings. And there are obvious reasons why financial institutions might want to share information about the creditworthiness of customers, and that raises issues about exemption. But the first question is whether or not that's a restriction of competition. And in that context, there's consideration of what's meant by restriction of competition. If we go to MS 3172, or bottom of 3171, you can see the heading, existence of a restriction of competition. Then at 48, over the page, 3172, you can see that the court says this is not an object restriction. You've got to examine the effects. Then at 49, you see an emphasis of the fact-sensitive evaluation that's necessary, very similar to the one we saw in 02. At 50, it says you've also got to look at potential effects. And then at 51, according to the case law on agreements on the exchange of information, such agreements are incompatible with the rules on competition if they reduce or remove the degree of uncertainty as to the operation of the market in question, with the result that competition between undertakings is restricted. So that is the point that I've just made to your lordships. And then at 52, in effect, it's inherent in the treaty provisions on competition that every economic operator must determine autonomously the policy which it intends to pursue on the common market. Thus, according to the case law, such a requirement of autonomy precludes any direct or indirect contact between economic operators of such a kind as to influence the conduct on the market of an actual or potential competitor, or to reveal to such a competitor the conduct an operator has decided to follow itself or contemplates adopting on the market, where the object or effect of those contacts is to give rise to conditions of competition which do not correspond to the normal conditions of the market, taking into account the nature of the products, etc. Now, those comments are made in the specific context here of information sharing. But the footnote to the Commission guidelines makes clear that this is a more general principle about the nature of restriction of competition by effect. What you're looking for is something that changes the extent to which an operator determines autonomously the policy that they're going to pursue on the market. And one of the key ways that an agreement or a concerted practice might do that is by reducing the degree of uncertainty between competitors as to how their competitors are likely to act. So, in our submission, putting it into a nutshell, if you're asking what is meant by an agreement that has the effect of restricting competition, the answer is, if the evidence shows that there's no difference in the degree of uncertainty that operators have about the way their competitors will behave, either in the presence or the absence of the disputed agreement, and no difference in the extent to which competitors determine the policy they intend to pursue autonomously, either in the presence or absence of the disputed agreement, then that agreement does not have the effect of restricting competition. Now, I've put it in the negative, but obviously the converse applies. You have to, in order to succeed, you must show that there is a reduction in autonomous decision-making. And if you can't show that, there's no restriction of competition. Now, that's very important. If you look at one of the things that's said in this case, it said the MIF puts a floor under the merchant service charge. It puts a floor under the price. That's not enough for an effects case to succeed. The question you've got to ask is, would there also be a floor under the price in the absence of the MIF? Would there be any difference between the autonomous decision-making in the absence of the MIF or in the presence of the MIF. Simply identifying that there's a floor under the price in the presence of the MIF tells you nothing about whether there is actually a restriction of competition. The claimant has to prove greater decision-making autonomy, greater rivalry, greater uncertainty in the absence of the disputed agreement. That then brings me to the claim against Visa and the particular characteristics of MIFs. And your lordships have, in the first core volume, in the SFI, an agreed summary of how four-party payment card schemes operate and of the role of the MIF in those schemes. And this is core volume 1. It starts at page 4830. In fact, the SFI starts at 4827, but I want to go to 4830.
Ms. Rose, I'm working off a different loose copy, so if I could have the paragraph.
Yes, of course, my lord. Paragraph 8. In fact, yes, paragraph 8 is the first one. It's page 4 of the document. You can see the heading, four-party payment card schemes and interchange fees. It's paragraphs 8 down to 21, and in my submission, all of these paragraphs are very important to an understanding of what's actually going on. So we're told first that Visa and MasterCard operate a four-party payment card scheme. And you can see there's a helpful diagram on page 4831 that tells you what that scheme is. There are actually 5 parties because the 5th party is Visa or MasterCard. So where it says platform, that's Visa or MasterCard. And then what you have is members of the scheme. So you have issuing banks who issue Visa or MasterCards to their customers. And their customers are the card holders. And then you have acquiring banks which provide services to the merchants that want to accept cards. And what happens is that the card holder will go to their bank, say, can I have a debit card? Issuer issues the debit card. They take the debit card to the shop. They present it to the merchant to pay for goods. The merchant accepts the card in payment. What then happens is that a signal goes to the issuing bank telling them that that transaction has occurred. The issuing bank is then under an obligation to pay the money to the acquiring bank, and the acquiring bank takes the money, passes the money back to the merchant, subject to its fee for its service, which is the merchant service charge. So that's the way that the scheme operates. And you can see there's a summary there at paragraph 12 of how that operates. And there are, as you can see, separate contracts between the card holder and the issuing bank on the one side of the market, and between the merchant and the acquiring bank on the other side. And that's why this is often called a two-sided market, because you have two sets of service providers, the issuing banks and the acquiring banks, each providing their services to different groups of consumers. But the two sides of the market are completely intertwined with each other. The market cannot survive or thrive unless both sides are operating properly. So if nobody wants to have a card, then there'll be no point in any shops accepting cards. Similarly, if no shops are prepared to accept cards, there's no point in anybody holding a card. So you've got two markets, but they're inextricably linked. And if we go to paragraph 12, you can see the terms in relation to card holders at paragraph, this is 12.3, page 4832. So this is the card holders contracting with the issuers, may include a fee payable by the card holder to the issuer for the use of the card, interest rate for the provision of credit, and incentives or rewards. So sometimes card holders have to pay to hold cards. More often in this country, cards are issued free, and you may actually get rewards for using your card. So if you use your credit card, you might get air miles, or you might get cash back. Merchants contract, this is the next paragraph, with the acquirers, who are providing services to them to enable them to accept cards. And the merchants agree to pay to their acquirer a fee called the merchant service charge, which is negotiated between the merchant and the individual acquirer. And that covers the merchant's costs, the acquirer's costs in providing the service and a profit margin for the acquirer. And then at 6, there is the obligation on the issuer every time a transaction happens to make a payment to the merchant's acquirer to settle the transaction. And then at paragraph 7, the Visa and MasterCard schemes make provision for the terms on which issuers and acquirers are to deal with each other in the absence of any different bilateral agreement made between them. All the terms we're considering in this case are default terms. They're all subject to any different bilateral agreement that can be made between individual issuers and acquirers. I don't want to have to keep saying default every time, but that's always understood. Whenever I'm talking about a MIF or a settlement at par rule, everything is default. These terms include issuers and acquirers settling transactions at par, i.e. at the face value of the transaction, and they also provide for the payment of an interchange fee on each transaction. Under both the Visa and MasterCard schemes, the default interchange fee, or MIF, is payable by the acquirer to the issuer on each transaction. It's either expressed as a percentage, typically in debit that will be something like 0.2, or sometimes it's a flat fee like 8p. Different MIFs apply to different types of transactions. So you might have a higher MIF for a remote transaction where the cardholder is not present, for example. And you typically have different MIFs for credit and debit. And then at 9, there's the point that this is a default rule. They're free to contract in different terms. But in practice, they all always contract on the default terms. And you'll see set out the reasons there given by both Mr. Justice Popplewell and Mr. Justice Phillips. Essentially, the point is that they have no incentive to do anything else. If we just go back to the diagram, the rules say, in default of a different agreement, the acquiring bank has to pay 0.2% of the amount of the transaction to the issuing bank on every transaction. Well, in that situation, the acquiring bank has no reason to agree to pay more than 0.2%, because they know if they don't agree to that, they'll only have to pay 0.2%. Equally, the issuing bank has no incentive to agree to accept less than 0.2%, because they know in default of agreement they'll get 0.2%. So the effect of this rule is everybody contracts on the default basis. And then at 10, the MIF, it says typically accounted for some 90% of the MSC.
Sorry, can I just interrupt?
Yes, yes, my lord.
And is that because each acquirer knows that, and each issuer and acquirer know that that's what all of our competitors are going to be doing?
That's right, my lord. And that's absolutely right, my lord. The whole of this, the way the scheme operates is transparent because the issuers and acquirers are members of the scheme. And so they've got the scheme rules. They know what the default says. The most important fact in this case is that that's what happens in the counterfactual as well. There's equal transparency. They equally know, and they equally have no incentive to contract on anything but the default. But I'm getting ahead of myself.
Yes, that's a critical point.
That is
critical building block in your case.
That's the critical point, my lord.
Yes.
It's the foundation of this case, and it's different from what the Commission found in MasterCard. It's not the only critical point, it's certainly a critical point. If the finding, putting it this way, if the finding of fact made by Mr. Justice Phillips had been different, if he had found that in the absence of the MIF, there wouldn't have been transparency, and therefore individual acquirers and issuers would have had an incentive to negotiate between themselves individual terms for settling transactions, then it would have been extremely difficult for us to win our case.
You say the absence of a MIF can be equated with a MIF of zero.
Well, we're getting ahead of ourselves because that's for a specific reason, which we
Yes.
haven't yet got to.
Well, I won't take you out
Yes,
of your
but
course.
your lordship's right, that's where we end up. But we have to build the castle from the foundations.
Okay.
I was just showing your lordship's paragraph 10 on page 4834, which makes the point that the MIF is 90% of the MSC. Now, that's true of these merchants. And what it reflects is that what you have sitting before you are some of the biggest and most powerful retailers in the United Kingdom. Sainsbury's, Argos, Morrison's. And that means they strike a very hard bargain. And what they're doing, this is because there is competition in the acquiring market, what they're doing is they're making their acquirers contract with them at a sum that barely exceeds the acquirer's own costs. And the main cost that the acquirers have is the interchange fee that they have to pay to the issuers on every transaction. If you were looking at small corner shops, you would find that the MIF was a significantly smaller element of the merchant service charge negotiated between those shops and the acquirers. Why? Because in that situation, the acquirers have more market power as against the corner shop, so they will take a much bigger margin. So the reason the MIF is 90% of the service charge is not because the MIF is monstrously and outrageously high. It's because the acquirers are taking a very low margin. So then, at paragraph 13, in the present proceedings, the MIFs, and remember, whenever we're talking about MIFs, we're talking about the default rule. There is a tendency in these cases sometimes to confuse MIFs with interchange fees. I will always try to say MIFs if I mean the default rule, and interchange fees if I'm just talking about an interchange fee. The MIFs at issue flow from the acquirer to the issuer. It's always in that direction in these rules. But they don't have to go that way. There are schemes where the MIFs make provision for fees to flow in the other direction. In other words, under this scheme, when an issuer settles a transaction, they don't settle it at 100% of the face value of the transaction. They settle it at 99.8%. They are holding back 0.2%, which is the MIF. But there are some schemes where when the transaction is settled, the issuer pays 100.2% of the face value of the transaction. They're paying a fee to the acquirer. Now, there are certain circumstances where you can see that that might be desirable for the schemes. Let's say you had a situation where there was difficulty persuading merchants to accept cards, and you're trying to incentivize merchants to accept cards. You might be trying to incentivize them to adopt a new form of technology that requires them to invest in that technology. And in that situation, you might want to give them an incentive on every transaction. So instead of the merchant paying a merchant service charge to their acquirer, you could have a situation where the merchant gets a reward from the acquirer every time they accept a card. In our market, it operates the other way. It's the cardholder who gets a reward for using a card. But it doesn't have to be that way. And that's a really important element in understanding a MIF. It can pass either way in this scheme. And that's not theoretical. There are schemes that operate in that way. And then the critical finding that I was just discussing with my Lord, Lord Hodge, it is common ground, this is paragraph 14, that a rule specifying the terms on which the transaction is to be settled between issuer and acquirer in default of bilateral agreement is necessary in order for a four-party payment scheme to operate. And then at 15, it's also common ground that a rule providing for a positive MIF is not necessary for the operation of a four-party payment scheme. Now, this is really the central battleground in relation to restriction of competition. The point that we make is this, that everybody in this case accepts that you cannot be comparing competition in this market with a market in which every individual acquirer and every individual issuer autonomously decide the basis on which they're going to settle transactions. The market won't work. Because in that situation, it's the issuer who has control of the funds because it's his client, his customer, who's the cardholder who has the money. And the issuer can say to the acquirer, I'm only prepared to settle this transaction at 80%. I'm going to take a 20% fee for settling the transaction. It's common ground, and it always has been in these proceedings, that that won't work. And therefore, that you have to have some rule that says if an individual and issuer and acquirer haven't agreed terms of settlement, the rule sets what those terms must be.
Well, I just wonder about that. I mean,
Yeah.
if a particular issuer says, I'm only going to, I'm going to charge you 20%
Yes.
as a MIF,
Yes.
then presumably the acquirer would then go to another issuer and say, well, what terms are you prepared to offer me?
My lord, it could have been analysed that way. The critical point from my perspective, and why fascinating as it is, I don't need to get into that debate, is that it hasn't been. It's been agreed by everybody at all stages, and you can see it here at paragraph 14, that isn't the right comparison.
Well, 14 tells us that it's agreed that a rule
Yes.
is necessary in default of bilateral agreement.
Yes, yes. But
But,
what that means...
but that doesn't exclude the possibility that there would be bilateral agreement.
No, my lord, of course. There's, and indeed, the rules don't exclude the possibility of bilateral agreement. All the rules we're talking about are always default rules. Now, I've made the point to your lordship that everyone agrees that in the factual situation, although they're only default rules, everybody contracts on them.
Because neither
incentive
party
to
has
do-
an incentive to
to
depart,
depart.
which is also a critical building block
Yes,
in your case.
that's right. And the critical finding of fact that's made by Mr. Justice Phillips, which has not been challenged, is that the same incentives apply if the default rule is a settlement at par rule. That's absolutely critical. Now,
Yeah.
Mr. Hoskins rightly reminds me that the answer to your lordship's question is the honour all cards rule. The point is that a merchant has to honour, or if they accept Visa cards, they have to accept Visa cards provided by all issuers. And that's the reason. But, my lord, we don't need to go into the reasons why you have to have a default rule, because the critical fact that's agreed in this case is that the right counterfactual involves a scheme rule that sets the terms on which acquirers and issuers must settle their transactions unless they've agreed to do something different. And the scheme rule that everybody agrees is the counterfactual, is the settlement at par rule. In other words, that the issuer has an obligation to pay 100% of the transaction price on every transaction.
If we accept that, then you're home and dry, aren't you?
Well, my lord, I
That's the critical-
respectfully agree, and that's why we submit we ought to win.
See, I mean, the whole point is
Yes,
that
there's no
well,
difference.
the argument against you is that competition depends on a lack of
Exactly.
knowledge throughout the entire market
Yes.
of what everybody else is charging.
Exactly, my
And it
lord.
doesn't matter whether they're charging 0 or 20%, provided they all know what everybody else is charging, then competition is eliminated.
My lord, that is my case.
Yeah.
That's my case. And that's why we say that the attempts to compare this to a cartel case are misconceived. Because let's say you have a cartel, which is a group of rubber manufacturers who all get together and agree that they're going to charge a particular price to tyre makers. If you ask what's the counterfactual is that they're not agreeing the price at all. They're each negotiating individually with the tyre makers the price of the tyre in competition with each other. And they have no idea what each other are offering to the tyre makers. That's the whole point. So, and you'll see in due course that that's a classic error that's made by Mr. Justice Popplewell in this case, that he seeks to compare this situation with a cartel. And indeed, it's an error that, with respect to him, Mr. Turner makes also when he talks about a bid rigging analogy.
So I mean, effectively, you say there cannot be a counterfactual
Yes.
where there is no default rule.
Yes, exactly, my lord. And therefore, what you see in this case is effectively two means by which the claimants have sought to get out of the logical bind that your lordships appreciated. First of all, they try to say there's something qualitatively different about a settlement at par rule and a MIF. And you'll see in their cases that they say, oh, well, the settlement at par rule is different because it doesn't set a charge. It's a zero charge. It's not a charge. It's not imposing any charge. So they're negotiating over the whole of the fee. It's completely misconceived. It misunderstands the nature of what this rule is. And they try to argue that there is some difference in the competitive process that means that everybody contracts at par, and the competitive process that means everybody contracts at the MIF. Now, those arguments were examined by Mr. Justice Phillips in great detail, as we shall see shortly, and rejected by him on the basis of the factual and economic evidence that he had. So, my lord, those are paragraphs 14 and 15. Now, then at 16, you have a very useful diagram which shows you the sequence of payments in a debit card transaction worth £100, assuming a positive MIF of 1%. In parenthesis, the MIF is not 1%. The MIFs are now capped by a European regulation at 0.2% for debit and 0.3% for credit. So this is simplified for the purposes of illustration.
No, but
So,
the claims here relate to past practice.
they do, but Visa's MIFs were never as high as 1%. But so this is just an illustrative figure for simplification. So here you can see the four parties, and in particular you can see how the transaction is settling here. That because there is a MIF of £1 due on the transaction worth £100, what actually happens is that the issuer is settling the transaction at £99. There is no difference between a scheme that says, in default of bilateral agreement, all transactions must be settled at 99%, and a scheme that says, in default of agreement, all transactions must be settled at 100%, and the acquirer must pay an interchange fee of 1%. It happens that both the Visa and the MasterCard schemes are phrased in the latter way. There are two rules, Rules 7 and 9 in the Visa rule book, one of which provides for settlement at par and one provides for interchange fees. But that is a difference of form only. The substance here is that what those two rules are regulating are the terms on which the issuer and the acquirer agree to settle every transaction. There's an explanation of how that works at paragraph 17. At 18, there's the point that Visa and MasterCard don't receive the MIF. They get a separate scheme fee that's not an issue in these proceedings. Then there's the point about the two-sided market, which I've already explained to your lordships. Then there's a point that there are also three-party schemes like American Express, where American Express itself operates as both issuer and acquirer. Typically, those schemes are more expensive for merchants. And then at 21 is the honourable cards rule that Mr. Hoskins rightly reminded me of. Now, three critical facts from that I want to stress. The first is 12.9, that even though the MIF is only a default rule, no one has an incentive to depart from it. And as we've already been considering, one of the key questions in this case are those incentives any different in the absence of the MIF in the agreed counterfactual? Is there any change in the economic incentives? Paragraph 13, MIFs can flow both ways, that you can have a positive or a negative MIF. And paragraphs 14 to 15 that we've already discussed in detail, that a default rule specifying the terms of settlement is essential to this scheme, even though it doesn't have to be a MIF. So, those are the critical facts. The claimants say that the MIFs have the effect of restricting competition. So, they have to identify how they say this market would operate without a MIF. There's never been any dispute about that question. One of the oddities about the Court of Appeal's judgment is, in parts, it reads as if there was some issue between the parties about what the correct counterfactual is. There's never been a dispute. between the parties about the correct counterfactual. Claimants accept that without MIFs, there would not be a situation where each issuing and acquiring bank agrees the terms for the settlement of transactions independently or autonomously. They accept that the schemes could not operate in that way. They accept that the counterfactual situation is one in which there is also a collective agreement of an association of undertakings, an agreement that in default of different bilateral agreement, all transactions must be settled at par, in other words, at 100% of face value. And that's the reason why we say this is completely different from a price-fixing cartel. The only difference between the factual and counterfactual situation in this case is whether the issuer is required on every transaction to settle it at 100% or whether it's required to settle it at 99%. The question is, does that have any effect on competition between acquirers for the business of merchants? There's another point that needs to be borne in mind, and that is that the rules requiring the issuer to settle all transactions at par and for the payment of the MIF are only one small part of the whole scheme of the visa rules. Other parts of the visa scheme allocate particular costs to the issuer or to the acquirer, and they include rules that impose costs on the issuer that benefit the merchant. Let me give you two examples. Issuers incur the costs of processing transactions. Now, that's obviously of benefit to the merchant who's a party to the transaction. That money is being paid by the issuer. Issuers also have an obligation to settle all transactions at par, regardless of whether the transaction is actually fraudulent, provided that the merchant has performed the relevant security protocols. So the merchant will get paid the full value of the transaction, less his merchant service charge, even if the issue was left out of pocket because there was fraud. Now that, of course, gives the merchant great comfort that he can rely on the scheme, but it imposes an incremental cost on the issuer because maybe 1 out of every 1,000 or 10,000 transactions, somebody else will have been unauthorizedly using the cardholder won't pay, and the issuer is left out of pocket. So if the issuer is required to settle every transaction at 100% at par, rather than at 90%, 99%, the issuer is going to incur a loss on every transaction because the issuer is incurring costs on those transactions. And if those costs can't be recovered from the merchants via an interchange fee, they will be recovered elsewhere. Now that means that you might get a situation, in that situation where, in fact you inevitably will, where the issuers have less incentive to encourage people to use their cards. If every time I use my debit card, my bank incurs a loss, my bank is not going to want me to use my debit card. It will make it more difficult for me and more expensive for me to do so. So far from people receiving rewards for using cards, they're more likely to be charged fees for using cards. Now, what that tells you is that any adjustment to the terms, the default terms on which the parties settle these transactions, is going to have equal and opposite effects on the two sets of consumers. It will increase the price for one set of consumers and decrease it for the other set of consumers. What it also tells you is it is a complete fallacy to regard settlement at par as zero, no charge. What the AAM say is settlement at par is like no charge. It's not. Settlement at par is an obligation on the issuer to pay 100% of the cover price on every transaction, whether or not they get reimbursed. That's not neutral. It's not the starting point, and it's not the lowest possible point, because it could be 99%, it could be 101%. 100% is no more neutral or nothing or the bottom than either of those other points. Now, what that tells you is that the MIF is not a price for a service at all. What the MIF is an adjustment to the terms on which an issuer is obliged to settle a transaction. Now, we have illustrated this point with a diagram which my junior, Mr. Pitchinen, who's an economist as well as a lawyer, finds embarrassing in its simplicity, but as a lawyer, I've found it useful. It's in the Appellants additional documents. It's at MS 7520.
Sorry, which bundle is that, Ms. Wren?
It's called Appellants additional documents. It's a diagram of what default settlement terms actually are. And you can see that the way we express it is it's like a balancing line. Oh, so does your lordship have it? It's called Appellants additional documents. It's one of the blue files.
I'm working outside. I've noticed I've another bookcase full. Thank you. I'm afraid it escaped my attention. I had a second bookcase full.
It's even worse than you feared.
Yeah, even worse, yes.
7520.
Yep.
So this is what the MIF actually is, an adjustment to default settlement terms. So the way we've expressed this with childlike simplicity is that you have a line that gives you infinitely negative MIFs and infinitely positive MIFs. And in the middle, you've got zero. The point is simply that zero is not the bottom. Zero is somewhere around the middle.
Remember, my maths teacher once telling me that zero isn't nothing, zero's something.
Yeah. And of course, there are some circumstances in which zero is nothing. If you've got a simple price and you say, I'll give it to you for free, then zero is nothing. But this is not like that because it can go negative. And that's why this is a mathematical style zero, not a nothing style zero. And that's one of the key fallacies which underlies the claimant's case, that they say zero is nothing. You'll see it also appears to have been a fallacy that the Commission fell into. But because the MIF can go negative, zero is not nothing. So let's say you have a situation where you don't have a MIF, you have a settlement at par rule. And where for the purposes of this example, the incentives of the issuers and the acquirers are all the same, so they're all contracting at the default position. They're all contracting at par. And they all know that they're all contracting at par because it's in the scheme rules, it's transparent. And the merchant goes to the acquirer and wants to negotiate a merchant service charge. And the merchant says to the acquirer, I've got to invest to accept contactless. And so I want a reward for accepting cards. And the acquirer says, I'm not going to pay you a reward for accepting cards because I have to operate in a system where I don't get paid by the issuer for providing acquiring services. I only get settlement at par, and I've got my own costs on top of that. So you're going to have to pay a sum to cover my costs and my profit margin. Now, as you can see, in that situation, the settlement at par rule is a flaw on the negotiation, just as any MIF is. So let's say you had a MIF of 0.00001%, or a settlement at par rule. The negotiation in either of those situations is identical. And let's say you had a MIF of minus 0.5. And in that situation, the acquirer says, okay, I can give you acquiring services for free. And the merchant says, well, that's still not good enough. I actually want to be paid to accept cards. And the acquirer says, well, I can't, because the 0.5% I'm getting from the issuer is just about covering my costs. Even the MIF of minus 0.5% is acting as a flaw under the negotiations. It means you can identify any default settlement rule, whether it's a positive MIF or a negative MIF or settlement at par, and you can always say that there is a flaw under that negotiation, and you can always say that you can hypothesize a still lower MIF, which would bring the flaw to a lower level and mean that the merchant service charge was lower. The lower the MIF going negative, the lower the merchant service charge, and eventually the merchant may be getting money instead of paying it. But there's no difference in competition in any of those situations.
And that's because the default rule is that to which
Yes.
everyone adheres.
Exactly.
And therefore,
Everyone's
wherever on this range
Yes.
you fix the default rule,
and you're always only negotiating over the margin.
so there is no autonomy to be had, is
That's
really
right.
what you're saying.
That's right. And it's said by the claimants, oh, well, when it's zero, you're negotiating over the whole of the charge. There's no imposed fee. The whole of the merchant service charge is up for grabs. But with respect, that's a complete illusion, because their assumption is that the merchant has to pay to accept cards and has to pay the acquirer's costs. But why should that be the case? Why shouldn't the merchant be in a position to negotiate a situation of free acquiring or where they get paid to accept cards? And the reason they're not contemplating that is they haven't considered that the MIF can go negative. So, my lords, yes, the MIF is a flaw. So is settlement at par. So is a negative MIF. And wherever you set the floor, you can always hypothesize a lower floor leading to a lower price. But in all those situations, competition is the same. And the other point is this: the lower that floor goes, the lower the price for the merchants, but the higher the price for the cardholders. So if you're saying it's just the higher price that's a restriction of competition, that leads you to an incoherent position, because it leads you to reduce the MIF to benefit the merchants, and then the cardholders come along and say, well, hang on a minute, I want a higher settlement rate, and this is a restriction of competition because it's increased the cost to me of holding a card. Now, what that shows you is that this price has nothing at all to do with a restriction of competition. And because it's not a price, it's an adjustment to the settlement in a situation of complete transparency in both the factual and counterfactual situations. Now, of course, it might be that because of the dynamics of this market, that price is inefficiently high. If you have a market where a price is inefficiently high because of the way the market operates, the answer to that is not to try to distort ex post competition law and treat it as if it were a competition problem. The answer may be that you need regulation. And my Lord Sales will be very familiar with this in the telecommunications field, that you have particular fields where prices are regulated because otherwise competition alone cannot deliver efficient economic pricing. That's exactly what's happened in this market. The European community has legislated, it's the interchange fee regulation, which your lordships will have seen referred to in the materials. And the effect of that regulation is that right across the EEA, there is a cap on the maximum MIFs that can be charged of 0.2 for debit, 0.3 for credit. And that's had the effect of bringing MIFs down very significantly to a level that the European institutions considers to be economically efficient. Now, There's a whole other debate to be had about whether their judgment of where the right place is correct or not. That's not, thankfully, a debate your lordships need to entertain. But what that shows is there's no regulatory gap here. There's no mischief that means that there is a pressing policy reason to try to adopt an expansive meaning to 1011. Indeed, it's wrong. It's wrong in principle to take a situation that has nothing to do with the restriction of competition and treat it as if it were, because of the prejudicial arguments that your lordships have seen by the claimants saying, oh, well, these banks are all getting together and using their market powers to make us pay more. Well, that doesn't tell you anything analytically useful about whether this is a restriction of competition, with respect.
Yes, and your case would also be that while the price, because it ultimately comes part of the MSC, may or may not affect competition among retailers, whether petrol pump providers or whatever, that's not the market we're looking at. We're looking at the acquiring bank market in this appeal.
Well, my lord, in my submission, there's never any effect on competition, because what the myth is, and this applies to any default rule, including settlement at par, is simply a common input to the cost base of all the acquirers, which is the same for all the acquirers. So all the acquirers start from the same position. Individual merchants will then negotiate, doing the best they can, and if they're these merchants, they'll negotiate a very tough deal with the acquirers about the level of the merchant service charge, and then the merchants will all be competing against each other based on the negotiation that they've had with their acquirers. Now, the MIF is not having any effect on that competition, any more than a payment of VAT would have. Just as everybody has to pay VAT at a set rate, doesn't affect competition because everybody's on a level playing field. So in my submission, there's no effect on competition anywhere in this process. What there is...
Unless the high price
yes.
of the MSC drove people out of the market, drove retailers out of the market, then it could affect competition if the number of players in the market shrunk. But that's not, again, that's not the case we're facing here.
Your lordship's theoretically right, but of course that's an argument that's it's not.
It's not the case you're having to.
It's not this case, no.
No.
So, my lords, very briefly, this diagram shows you three things. First, that the MIF is not a simple price that starts at zero. It's a transfer of value from one side to the other of the two-sided market, which can be negative. Secondly, the same is true of any default settlement rule, including settlement at par. And thirdly, it's purely fortuitous, given the costs and benefits on both sides of the market, if settlement at par is or is not the most efficient point on this scale for transactions to settle. It might be a highly inefficient place because of the costs that issuers are incurring in settling transactions. So there's nothing natural or neutral about 100%. Now, over the page, very briefly, is what we say is the way that the claimants envisage this case, as if it were a price starting from nothing. It's an equally pitifully simple diagram. And we say that that is the essential analytical flaw that underlies the claimant's case. So, my lords, that's what I wanted to say about the nature of MIFs and the way that competition operates in the factual and counterfactual. And I now want to turn to the judgment of Mr. Justice Phillips, and what your lordships will see is that the points that I've just made to this court are indeed the substance of the judgment of Mr. Justice Phillips. And his judgment is in Core Volume 2, page 5757. And if your lordships go to 5769, at the bottom of the page, paragraph 47, you see the heading, Analysis of the Role of Interchange Fees in a Four-Party System. And this is a passage that the Court of Appeal explicitly approved Just for your Lordship's note, it's paragraph 6 of the Court of Appeals judgment, MS 5208. So he describes in this paragraph the two-sided market, how the two sides are closely linked and dependent on each other, and precisely what benefits merchants gain from card transactions is a matter of dispute, but it's common ground they benefit, at least to the extent that card transactions are cheaper for them than cash. And then at 48, interchange fees have the effect of moving value from one side of the system to the other, effectively incentivising the participants on one side to engage in card transactions at the immediate expense of those on the other, but possibly to the longer-term benefit of the latter. Then he considers in detail the relevant economic models for establishing what's the efficient level of a MIF. I don't intend to go to that. I think Mr. Hoskins may deal with it to some extent at least. And he refers to the regulation by the European Community through the interchange fee regulation. And then we come to page 5775, paragraph 80, where you see the heading, the true nature of an interchange fee. Whilst the focus of attention in these proceedings is on interchange fees, and in particular MIFs, in my judgment it is important not to lose sight of the fact that such fees are by way of adjustment to the principal sum passing between issuer and acquirer, and then on to the merchant, equivalent to the price of the goods or services purchased with the Visa payment card. The scheme prevents the issuer seeking to discount the principal payment for the acquirer, or the acquirer seeking a premium, by the requirement that transactions must be settled at par, 100% of the price. The interchange fee is expressed as a separate fee, calculated as a percentage of the price or a fixed sum for the transaction. However, as it's a sum passing between the parties to the underlying principal agreement, calculated by reference to that payment, it could equally be expressed and is economically equivalent to a discount or premium. An interchange fee of 1% is the same as settlement of the transaction at 99% and results in precisely that level of settlement. Settlement of par with no interchange fee is the equivalent of an interchange fee set at 0. Now, that's a finding of fact made by this judge based on his analysis of this scheme and the way it operates. In my submission, it is entirely correct, and nobody has produced any good reason for disagreeing with it. Then at 82, once that's understood, certain aspects of the interchange fee become clear. It's not a simple one-way price for services, but is an adjustment to the amount the underlying principal payment is settled. A change in the level of the interchange fee increases the cost of the transaction for one side and decreases it for the other side. There's no obstacle to the interchange fee being a negative figure. And then he makes the point that that's actually the situation in some jurisdictions. And then at the bottom of that paragraph, just below E, it is noteworthy that none of the previous decisions considering the competitive aspects of the MIF appear to have taken into account the possibility that the MIF might have a negative value, both in theory and in practice. And he's there identifying a key distinction between the way he approached this problem economically and the analysis conducted by the Commission. We then see...
I'm sorry,
yes.
saying in 82 Roman 1 that it increases the cost on one side and decreases it for the other side.
Yes.
In the system we've got on the facts of this case,
Yes.
Isn't simply a question of decreasing costs, is it? The issuer, effectively, the MIF is paid by the merchant
Yes.
and retained by the issuer, except to the extent that the issuer chooses to pass on the benefits to cardholders.
Yes, when he's saying costs, he means costs to cardholders. So,
I see.
Yes, so if he's talking about the seesaw effect that I was referring to earlier, so that if you have a situation where issuers are making a loss on transactions, they'll make it more expensive for you to hold a card, one way or another. So it's the seesaw effect, because all the MIF is doing is transferring revenues or costs to one side or other of the two-sided system.
Yeah.
So you've got the two interrelated markets, two interrelated groups of consumers.
Yes, and the difference between the merchants and the issuers
Yes.
is that the issuers will be, I imagine, and indeed the acquirers for whom the system is neutral, will be represented in the association which forms Visa, which fixes the MIF.
Yes. Now, of course, the incentive for the association is to fix the MIF at the level that maximises the use of cards. Now, whether that's the economically efficient level is open to question. And that's why it might be a market in which you need to have regulation. And that's the point I was making earlier, that that's got nothing to do with competition. Because the point that your Lordship's just made to me, which is the parties who are fixing this price are doing it together and it's impacting on the groups of consumers, applies whatever rule they reach. It applies if it's settlement at par, a negative MIF,
Yes.
or positive.
Yeah.
So at no point can the claimants ever identify a difference in competition. You're going to hear a whole series of statements from them about what's wrong with MIFs. And every time the answer is, but that would be the same in the counterfactual. And that's really the answer to this case. So that's his understanding of the nature of MIFs. And in my submission, that is correct, and it's fundamentally different from the understanding of the Commission and the analysis of the Commission. Then, at 98 to 100, you can see that Mr. Justice, so this is 5780, Mr. Justice Phillips considers the relevant counterfactual. And you can see Sainsbury's and Visa were broadly in agreement as the appropriate counterfactual. And the agreed characteristics are as follows. First and foremost, the restrictive provision, the setting of MIFs, will be absent, leaving issuers and acquirers free to agree the payment of an interchange fee, a BIF is a bilateral interchange fee, but not having one imposed in default of agreement, and no MIF counterfactual. Second, the scheme would continue to provide that transactions would be settled at par, and also, if necessary, would prohibit ex post pricing. That is, it would prohibit agreement as to a BIF reached after a transaction is concluded. These provisions would be necessary to prevent issuers holding up transactions. So those are the features. And as your Lordships can see, and as we'll see further, the case that's being mounted by Sainsbury's is that in that situation, the acquirers would be free to negotiate interchange fees on an individual basis. So what they're envisaging is that in the counterfactual, there would be a competitive process that, on their argument, doesn't exist in the factual. That's the factual argument that you're going to see comprehensively rejected by the judge. So the judge then at 99, the crucial aspect of the above counterfactual is that it sets a default position for the settlement of transactions, just as does the rule which provides for MIFs. This reflects the fact that Sainsbury's accepts that some collectively agreed default rule for settlement of transactions was essential for the scheme to function. And then at 100, the default rule proposed as the appropriate basis for the counterfactual is settlement at par with no ability to hold out for an additional fee, which is plainly and exactly equivalent in economic terms to setting a MIF at zero. All the expert economists accepted that was the case. So there was a complete consensus, and your Lordships can see why, having seen the way that the scheme operates, that there is no difference conceptually, economically, between a scheme rule that says you must settle all transactions at par, full stop, in default of agreement, and a scheme rule that says you must settle all transactions at par and there shall be a zero multilateral interchange fee unless you agree something different. Those two scheme rules are identical. And in legal terms and in contractual terms are the same. The parties have a contractual obligation to settle at par unless they agree something different. That's exactly the same as saying that their contractual obligation is to settle at par with no MIF unless they agree something different. It's a distinction without a difference. So he then goes on to consider the comparison between competition in the scheme with MIFs and in the no MIF default SAP counterfactual. Now, that is the entirely orthodox and correct approach to seeking to determine whether or not a restriction of competition by effect has been shown in this case. He's identified a counterfactual, which is in fact common ground, and now he's going to compare competition in the factual with competition in the counterfactual. And at 102, he makes the point that in the actual situation, even though the MIF is a default rule, there's no incentive to agree anything different. So that's set out at 102. And then we see how Sainsbury's put its case at 103. Sainsbury's asserts that the UK MIF thereby restricts competition in the acquiring market in two principal respects. First, it distorts the competitive process because it removes uncertainty among acquirers about what their competitors are paying issuers and reduces dramatically the scope for them to compete on price. In other words, and this is my interpretation, the MIF reduces competitive intensity as to the level of interchange fees to nil. So the key argument that's being mounted is there's a difference in the economic incentives in the counterfactual and there's more uncertainty in the counterfactual. Now, at 104, he correctly identifies that Visa's case is that we don't dispute that there's no incentive to depart from the default and the factual. Our point is that the same is true in the counterfactual. And you can see over the page Visa's key contentions. In the no-MIF counterfactual, issuers and acquirers would still not negotiate bilateral interchange fees, but would proceed on the basis of the default provisions, settlement at par, for exactly the same reasons as apply where there's a positive MIF. There would therefore be no difference in the competitive forces, the competitive processes, or the competitive outcome. Issuers and acquirers would proceed on the basis of the default set by the scheme, equivalent to a zero MIF. Merchants would have no ability to negotiate an even more favourable interchange fee outcome, a negative MIF. The only difference would be the level of the interchange fee, not by reason of increased competition, but because the default interchange fee would implicitly be set at zero rather than a positive figure. Now, that was the essence of our case there, and it remains the essence of the case that I've developed to your lordships. Now, as the court can see immediately, there's a factual dispute there about what would happen in the counterfactual. And we can see at 105, the judge acknowledges that Visa's contentions are contrary to the European judgments, and he therefore gives them very careful consideration. So it cannot be said that he hasn't given careful thought to the European cases. Now, Sainsbury's principal pleaded case before Mr. Justice Phillips was the case you've just been looking at, that there would be a difference in the competitive process in the counterfactual. We can see this at 112. So they amended their pleadings to plead as their primary case that if Visa had not been entitled to deduct any interchange fee in the absence of bilateral agreements, Sainsbury's would have had the benefit of bilateral interchange fees lower than the MIFs it in fact paid. Now, that was actually the finding of fact that was made by the CAT in Sainsbury's claim against MasterCard. And Sainsbury's adopted it as its primary case before this court. And in principle, that is a coherent argument as to why a MIF might have a restrictive effect on competition in the acquiring market. If it was right that in the counterfactual situation there was more uncertainty, less transparency, and a greater economic incentive for acquirers to negotiate lower interchange fees on a bilateral basis, then there would be more competition in the counterfactual. So there's nothing conceptually or legally wrong with that argument. The problem with it is that it collapsed on the facts, because all the evidence, and remember the burden of proof was on Sainsbury's, all the evidence in this case was that in the counterfactual, the economic incentives on issuers and acquirers would be identical to the economic incentives in the factual, because the settlement at par rule would be a scheme rule, it would be just as transparent as a positive MIF, and there would be no incentive on the acquirers to agree any interchange fee or for the issuers to agree anything different. Both sides would contract at the default, just as they do in the actual situation. That was agreed by every single economist who gave evidence, and it was also the evidence of the factual witnesses. Sainsbury's had actually served a witness statement from one witness, Mr. Brooks, who appeared to say something different, but when he was cross-examined, it turned out that he'd misunderstood the counterfactual. He had wrongly thought that the counterfactual was one where there was no default settlement at par rule, but purely a situation where settlement had to be agreed on a bilateral basis. So Sainsbury's case, their primary case, collapsed on the facts. That factual case is considered in detail by the judge by reference to the evidence at paragraphs 117 to 120, which I don't propose to go through in detail. You can see the finding of fact at 120. The gist of the expert's joint view was that the competitive situation of the counterfactual scenario would be exactly the same as in the real world. In either case, there would be no incentive to depart from the default, regardless of the level at which the default was set. So that's the finding based on the evidence. So what then happened was that by the time it came to making its closing submissions, Sainsbury's had backed off from what had been its primary case, although it hadn't abandoned it. And we see at 124 and 125, the judge describes this process. That their written closing argument didn't positively assert bilateral interchange fees would be likely to arise in the counterfactual, but did not entirely abandon the idea. And then at 125, Sainsbury's primary answer was not that BIFs would be agreed in the counterfactual, but that if no positive interchange fee emerged, such outcome was itself the result of the competitive pressure and acquirers having to compete for merchant business. That was the basis on which Mr. Brealey QC presented the case for Sainsbury's in oral closing submissions. Now, just pausing there for a minute, what Sainsbury's are saying is this. They're saying if you have a scheme with a default interchange fee of 0.1%, that's a restriction of competition. It's imposed on the acquirers, and they have to pay it, and that's a restriction of competition. But if you have a scheme with a default settlement provision of settlement at par, that's not imposed on the acquirers or the issuers. The fact that the parties are paying it is the result of a competitive process. Now, not surprisingly, the judge was not convinced by that argument, because it makes no sense to say that a term of settlement that says the issuer must pay 99.9% of the fee is imposed and not competitive, but a term of settlement that says the issuer must pay 100% of the face value is the product of a competitive process. In both cases, the terms on which the transaction settles is the result of the default scheme rule to which the parties are reverting because they have no incentive to do anything else. There's no difference in the competitive process. That's what the judge meant when he said there's no magic in zero. You'll see this is a phrase that the Court of Appeal turned to, and in my submission they wholly misunderstood what the judge was saying here. He was responding to Sainsbury's argument that any default settlement rule that involves an interchange fee is a restriction of competition, but a default settlement rule that is settlement at par enables a competitive process, even if all of these rules result in everybody contracting at the default. And he was just saying that's nonsense. There's no difference between 0 and 0.001 or minus 0.001. So that's the argument. And the judge rejected that argument. We've already seen that he found that there would be no negotiations and no bilateral agreements between issuers or acquirers in the counterfactual because the incentives will be the same. And you see at 127 that he makes that point again, and he makes the point that the market forces are identical in both cases. Then at 131, we see an elaboration of Sainsbury's argument, and the argument that settlement at par is in some way the fixed and obvious starting point for a transaction. Then at 132, Mr. Briley didn't accept that no MIF default SAC counterfactual was the same as a zero MIF. He recognised that the 5 expert economists, in parenthesis, the reference to 5 there is because there was an economist who gave evidence for Tesco in a written statement, but was not cross-examined because Tesco settled before the trial started, had agreed that those 2 situations were economically equivalent, but he maintained they nevertheless involved a different competitive process. The former was an agreement to pay the full price with no agreement reached as to an added fee. The latter was an imposed fee of 0. Now, with great respect to Mr. Brealey, that is nonsense, because there's never an imposed fee. The terms of settlement are always default terms. The parties are always free to agree different terms if they choose to. It's just that in one case, the default settlement provision is 100%, and in another, it's 99%. So that's a semantic distinction with respect. And the judge thought so too. He says at 133, that argument's misconceived. There's no difference in the competitive process in the 2 scenarios, in the absence of bilateral agreements. In either case, the market will not deviate from the default settlement rules set by the scheme, notwithstanding that the market participants are free to do so. To the extent that there is a competitive process, in either scenario, such process drives the price to the default setting. Second, the argument's dependent on drawing a bright line between settlement at the transaction price and a MIF. Mr. Brealey seeks to categorise the former as some sort of basic entitlement and the latter as an imposed fee. However, there's no such natural or obvious distinction. There's no a priori reason why settlement of a financial transaction should be at par, rather than at a discount or at a premium. And interchange fees are no more or less than another way of expressing such a discount or premium if they have a negative value. It's like somehow saying purchasing a bond at its face value is in some way the natural and obvious thing, rather than at a discount or a premium. And then thirdly, he says it's fallacious to regard the default MIF as being imposed, where a no MIF default SAC rule is not imposed. Both are default provisions mandated by the scheme regulations, providing the parties with the certainty of a fallback provision. Fourth, this is 136, the fact Mr. Brealey is forced to insist that the no MIF default SAC counterfactual is conceptually distinct from zero MIF reveals the illogicality of his position. There's no economic, practical, or legal difference between the 2 situations. And then at 137, the effect of the argument is any level of MIF on the infinite scale from infinitely positive to infinitely negative. I like to think this is the judge here reflecting my childishly simple diagram. Including an infinitesimally small level is deemed to be a restriction of competition, all in comparison with an infinitesimally small point in that scale equating to there being no MIF. But there is in this context no magic in the number 0. No reason why it represents an inherently more competitive situation at any other level. So there you can see what the judge means by the magic, no magic in 0. He means the competitive process at settlement at par is identical to the competitive process with a MIF. And then we see at 138 the argument that he's bound by the European MasterCard cases, which I'm going to come back to. So that's how he demolishes the Sainsbury's argument, and in my submission, that analysis is entirely correct. He then comes on to a different way the case had been put by AAM before they dropped out of the proceedings. This is at paragraph 152. Does setting a MIF, it's page 5795, does setting a MIF infringe Article 101 because it acts as a flaw for the MSC? And he acknowledges that that was the finding that had been made by Mr. Justice Popplewell, and at 154 that he'd be reluctant to depart from a finding of another judge. But he concludes, he says, I am persuaded by Visa's arguments that the finding reveals an incorrect approach as a matter of logic, economics, and the applicable legal principles. The suggestion a MIF creates a flaw is no more than another way of expressing the fact that it's a default level of interchange fee and therefore determines a default level of settlement from which no issuer or acquirer will agree to depart. It equally creates a ceiling for the interchange fee. Secondly, the situation is exactly the same at any lower level of MIF, including 0 or its equivalent and no MIF default SAP counterfactual. At that lower level, the default settlement rule still provides a default level of interchange fee and therefore, because of a lack of competitive pressure, a floor and a ceiling for that fee. The only difference is the level. Mr. Justice Popplewell rejected the argument, stating, in a no-MIF counterfactual, the alleged vice is not the same. There is no flaw, but a zero MIF most certainly does give rise to a flaw in economic terms and as a matter of logic. In the two-sided market, prevents the possibility of market forces driving the MIF to a negative level. And he says that's not really theoretical. That's the point we've been discussing earlier. And then he makes the point that effectively Mr. Justice Popplewell is adopting the same fallacy as Mr. Brealey. Then he addresses an argument that was made about a lower positive MIF. And then at 159, the argument that the MIF creates a flaw below the MSC ultimately equates to the argument that a MIF restricts competition purely and simply because it raises interchange fees above the level they be in the counterfactual world. And he's already explained why that's wrong as a matter of competition law. And your lordships have my submission about why the judge was right about this. An agreement that leads to a higher price is not per se a restriction of competition. It must be the restriction of competition that's leading to the higher price. And then he makes the point that it wasn't the way the case was put by Sainsbury's in closing arguments, and he also says it's instructive to note certain aspects of the evidence called by the Arcadia claimants and the arguments they put forward in this respect. And here he sets out a summary of the evidence that was given to him by the AAM claimant's expert witness, Mr. Dryden. So this is the expert called by the claimants. And it was the evidence of this expert that there was no difference in the intensity of competition in the counterfactual and factual world. If we just go through this rapidly, it's a very important paragraph, but I'm conscious of the time. So Mr. Dryden, who was called in both cases, accepted there'd be no greater or lesser degree of competition in the sense used by economists, and I would add by lawyers, whatever the level at which the MIF was set, including 0. His analysis was on the assumption that as a matter of law, an increase in the level of MIF was a restrictive effect. On that assumption, which he accepted was a legal question, he accepted any level of MIF would be deemed to be restrictive of competition in comparative to a lower MIF. He readily accepted that extended to a 0 MIF, which he regarded as the same as the no MIF default SAP. And he accepted that that would be restrictive in comparison with any negative MIF. So what's being said by the claimant's expert is wherever Visa sets this default settlement rule, it will always be a restriction of competition because you can always hypothesize a lower one, which will result in a lower price. That's obviously a paradox because everyone agrees the scheme can't function without a default settlement rule, but the claimant's expert witness is saying wherever you set the fee, including 0, it's going to restrict competition. That's obviously nonsense. He accepted
Are you going to deal with what seems to have been the argument that the judge rejected, that the no MIF counterfactual would result in a zero being paid by way of BIFs?
Yes.
Because of essentially because merchants were under the danger of free riding by other merchants.
Yes.
On the back of anything they paid, and so because of that danger, they would be unwilling to agree to pay any BIF, and so the argument,
Yes.
as the judge presents it, obviously he's rejecting it, but it seems as if it may have been. But it's one thing to set a default MIF where the effect of that is to eliminate any operation of the market because the critical participants know what everybody else is charging. That's not the same as a situation where there is no MIF, but where effectively as a byproduct of the hacker rule, there's a danger of free riding, which would compel all merchants to adopt the same position, namely we won't pay anything, and the acquirers would accept that.
My lord, he does examine that. He examines it in detail on the facts.
Yeah.
It's particularly
But it's not so much the facts. It's the fact that he rejects that as being the operation of a competitive market.
Yes, but the point he makes is that there is no such distinction, because what the judge finds is that in fact there isn't any difference at all between the parties' incentives in a situation where there's a MIF of 0.2 and a situation where there's a MIF of 0. In both situations, there's no issue about free riding or anything of that nature. Everybody just pays the default. And all the economic incentives are the same in both situations. So he is essentially rejecting the reasoning that was adopted by the CAT, because
Yes, I think you're missing my point. The argument is that whatever, it's the existence of a MIF, which is a restriction of competition, whether it's set at 0 or 2% is really neither here nor there. But the existence of the MIF means that acquirers will simply pass it on because there's no competitive incentive to do anything different. And so there is no competition generating the level of if that is paid. In the absence of a default rule, it's in principle open to merchants to negotiate with acquirers, and acquirers then to negotiate with the issuers. But the nature of the market is such that there is a danger of free riding, an appreciable danger, which results in the merchants being unwilling to pay anything, and the acquirers have no interest in charging them anything, and so the situation will settle at a level of payment at par.
Well, but the point is, both the rules, both the factual situation and the counterfactual situation are default rules. Neither of those situations prevents parties entering into different agreements. So let's say you have a MIF of 0.1%, but the acquirers want to argue that they shouldn't be paying any interchange fee at all, and they want to negotiate with issuers on that basis. Or they want to say they want to pay a higher one. Let's say particular merchants say we're willing to pay a higher interchange fee because we're getting so many benefits from the stimulation of card usage. You have exactly the same problem of free riding. So the point is that all of the economic incentives, including the free riding issue, which is one of the reasons why everyone defaults to the default, are identical. And whether you call it a 0 MIF or a settlement at par rule makes no difference. What's significant is only that it's a default rule. The parties are always free to negotiate a different interchange fee, always, different settlement rules, but they never do. Whatever your default rule is will always be the rule that applies.
Yes,
because all the economic reasons your lordship's given me for the factual and the counterfactual actually apply in both.
Yes, but it might be said that in the counterfactual situation, the outcome is the product of the economic forces operating essentially in the merchant market. So it's the operation of a market that's generating the result, whereas in the MIF situation, it's the setting of the MIF by Visa which generates the outcome.
But Lord, in both cases, it's the setting of the default term that generates the outcome. Because, again, your lordship's implicitly assuming that what the merchants want to do is just pay the acquiring costs, but not an interchange fee.
Yeah.
Let's say the merchants in your hypothetical want to be paid for accepting cards. They don't have any market power. They don't have any power to negotiate a basis on which they're going to be paid for accepting cards on the basis that the issuer has to pay the acquirers, because the issuers and acquirers are all going to settle at the default interchange. So in both of those situations, the only market power that the merchants have relates to the acquirer's margin. And it's an illusion, because if you regard zero as nothing, you think, oh, well, they're negotiating over the whole price. But once you realise that the merchant could be saying, I want to be paid for accepting cards, you realise that actually there is no difference between those situations. Market forces are resulting in a lower MSC to the extent that the merchants can drive down the margin of the acquirer, but have no impact on the level of the MSC to the extent that it is dictated by the default settlement terms, whether those are a positive MIF, a negative MIF, or settlement at par. It's the same in all circumstances.
Now, is that a convenient moment?
Yes, it is, my lord.
Thank you very much. 2 o'clock.